Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, your toast is begging, please.
Welcome to the show, everybody. I'm Seth Nelson, and I'm here, as always, with my good friend Pete Wright. Excuse me, got a little frog in my throat, Pete, because we're talking about pleadings. I get so excited.
Excited and nervous.
But we are going to dive into the intricate world of divorce proceedings with a focus on pleadings. Oh my God, Pete, a legal term. What are we going to do?
I don't know.
We're going to breathe. We're going to take it easy. We're going to be fine. I promise you. Okay. But what we're really going to do is explore the crucial document that sets the stage for the legal action. So this might be called a petition. It might be called a counter petition. And we're going to discuss how these filings, you file it in court, you take it to the clerk's office, and it's all electronic now, but how it can influence the direction and the outcome in your case. Super, super important.
All right. Is it really super important, or are you just such a nerd for legal stuff that you get excited about pleadings?
Those aren't mutually exclusive. They can be both. Come on now.
Okay. So you introduced it as a legal term. Tell me what do I need to know about a pleading?
The hardest thing about pleadings is it happens at the beginning of the case. You're so overwhelmed. You've been thinking about divorce for 3 years, or it just took you by surprise.
Mm-hmm.
But you finally have the courage to talk to a lawyer. You just felt compelled and backed in the corner where you have to talk to a lawyer. So here we are, and you get them on the phone or you're in their office, and now they say we have to file in court. People get freaked out about, I am going to file for divorce, because it has this sense of it's real.
Mm-hmm.
So there's this emotional, really heavy-handed, just weighing on people, right? That, oh my God, we're going to file, or I'm going to file. And then you get hit with, well, I want him to file. I want her to file, because they don't want to be the one as the one that actually did the filing in court.
Sure.
Now, these might be people that have had affairs. These might be people that have talked about divorce, that are, like, it's just this emotional baggage that they don't want to be the one that, oh, well, you filed, woe is me. Well, yeah, I filed because I didn't think it was a wise idea for us to remain married, and I wanted us to show our children, though it might not be together, what a healthy relationship looks like, right? So yeah, I filed.
Okay. So when you say file, because I'm a rube, you say file. That's entering a pleading. Is that entering a plea? Is that
No, it's not like
what is
criminal
that?
court, right?
Okay.
It's where you fill out legal documents
Okay.
and you sign them, and your lawyer will take them to the courthouse. I'm going to go
Mm-hmm.
old school now. They're going to hand deliver them to the courthouse, and they're going to stand in line and wait to meet with an assistant clerk of the court. And
Okay.
you're going to hand that assistant clerk of the court your documents, and you're going to say, I am filing for divorce. Here we have all our paperwork together. We have our filing fee ready to go, and you pay it, and the clerk stamps it and accepts it and creates a court file.
Okay.
That's how it's created.
Okay. So is any formal filing like this related to the case considered a pleading?
No, that is a great question. And this is nuanced. So a lawyer, excuse me. God, this cough's just not going away, Pete. So a pleading, technically, check your local jurisdiction, get with your lawyer, is the document where you're asking the court to get you divorced.
Okay.
Okay. Now, I will also file what's called a notice of appearance. And that is a filing where I tell the court and anyone else that looks in your court file that I have the honor of representing you. And I am now counsel of record, because I am your lawyer on the record, counsel of record.
Okay.
And I'm going to stay counsel of record until there's a judge that signs an order that says I'm no longer your lawyer in this case, or we have a final judgment
Mm-hmm.
and your case is over. And then 30 days after, I'm considered not to be your lawyer in that case anymore. Now,
Okay.
that's not a pleading. That's a filing.
So now
Okay.
we have pleadings and filings.
Right. And we're going to talk next week about motions. I think 2 weeks in a row, we have so much to talk about motions. We might do
Oh my
that.
goodness. Okay.
So a motion is not a pleading.
So
Okay.
can is it fair for me to assume that or to just presume that the pleading is the initial filing that starts the case,
It
the
is,
court file?
it's the document that's going to be called a petition for dissolution of marriage.
Got it.
A
Okay.
petition. Okay. If you're in a civil case, it's called a complaint. Okay.
Okay.
Criminal law might call it something different. But
Okay.
in Florida, it's a petition for dissolution of marriage. And then the other side will do an answer. So there's a petition and an answer.
Is that
Okay.
a counter petition? Is that it?
Nope. We're getting
Okay,
there.
answer.
You're
I'm
one
sorry,
step
I'm reading
ahead.
ahead. It's
You're good.
right. You,
You're good.
okay. All right.
So I sue you for divorce, Pete.
Okay.
You file your answer where and we're going to get into details on this, where you're going to admit or deny or say, I just don't know every single allegation that I put. Okay. You could stop right there. You could say, Seth, I'm not going to sue you for divorce. You sued me and I answered, but I still want to be married. So I'm not
Mhm.
going to file for divorce. There's a lot of problems with that we're going to discuss, but
Okay.
you don't have to do what's called a counter petition. 99.9% of the people do. And so then you would file an answer and a counter petition. And now you sued me for divorce. And
Okay.
now I file an answer to the counter petition.
Okay.
Okay. So I
You
hit the
just
ball
said
over the
something
net.
really
I
yeah.
hit the ball over the net. You hit it back and you say, I answer and I'm one upping you. I'm suing you too. And now I got to hit the ball back over the net and answer. Okay.
Okay. You said some things, I don't wanna if it's too early to get into detail, please tell me to pound sand. But you said some
Pound sand.
things. Got it. What's next?
Keep going.
Um, that you said some things that I thought were interesting. One, in the pleading, right? In the petition for dissolution of marriage,
Yeah.
I am laying out allegations to build my reason for divorce, correct? Is that
No, part of it is your reason for divorce.
yeah.
And in Florida, your reason for divorce is there's irreconcilable differences. That's the reason.
Oh, okay.
You are
And so when
not,
you say the answer, like if you file that irreconcilable, my answer is what? I
yes,
have to yes or
you
no.
have to say admit there's irreconcilable, or you deny,
Okay.
nope, there's not, right?
Mhm.
Or you say without knowledge, therefore denied. Like, I don't have enough information.
Got it.
I have to do
Got it.
more research. So I'm going to deny it, but judge, it might be irreconcilable. Okay.
Okay. All right.
99% of the cases that we file, 0.999, irreconcilable differences, admit.
Okay. So
Okay.
just give me a circumstance where the 1%, right? Or the 0.1%. What else might you see in a petition?
Well, if you're filing, you have to have certain words in your petition to make it a proper petition for dissolution of marriage.
Okay.
So you cannot file a petition for dissolution of marriage. You can title that and it can say, we're married. He doesn't paint the house well. I want a divorce. You
That
have
seems
not complied with the
yeah.
laws.
That seems light.
A little light. Okay.
Okay.
You have
All
not
right.
complied. So I would file a motion. If someone sent that to me, I'd pick up the lawyer and be like, what are you doing? The
Yeah.
other thing I'd say is, are you going to amend your petition, redo it? You don't have to ask the court. I'll agree to it. Just file an amended petition and lay out what you're supposed to do. Otherwise, I'm going to file a motion to dismiss and I'm going to say, Judge, under the statute, they have to allege certain things. They have to have allegation number 1, allegation number 2, allegation number 3. For example, Judge, they have to allege irreconcilable differences. They fail to do so. You need to dismiss it. Okay.
Okay. So what that might be is he doesn't paint the house well, but we're not putting that in the petition. We're saying it's irreconcilable differences.
That's right.
Okay.
And you're going to say in Florida, check your local jurisdiction on this,
Mhm.
that one of the parties has been a resident of the state of Florida for at least 6 months at least 6 months prior to the date that you drop that petition off at the courthouse, prior to the date of filing.
Okay.
Why do we need that? Because in Florida, they don't want someone from, I don't know, say Oregon, right?
Okay. Okay. I see where
Looking
this is
around the
going.
states, all around the US, and saying, you know what? I really like Florida law when it comes to the divorce. It's going to favor my case. So I'm going to move to Florida with my wife. And 3 days later, I'm going to file because I want to take advantage of their laws.
Okay.
Nope. You have to be a resident for 6 months. Okay. Then part of it is, well, you've been a resident, but where's the last time the marriage was intact? So there's some jurisdictional issues. Does the court have the power to hear this case? That has to be in the petition, telling the court, I believe you have the power to hear this case. Okay.
What would be the sort of constituent argument for the court to make that says, no, we're not going to hear this case. You got to go back to Arkansas.
So you have a case where the parties are living in Florida and one of the spouses takes a job in, let's just call it, I don't know, Boston. Okay.
Okay.
Moves to Boston. The husband stays back and they're selling their house and or they're ending their lease. Let's do it that way. They're ending their lease. And so staying back and they're going to pack up stuff because the job's starting early. I got to go now.
Right.
School year's not done for the kids. Summer's not out yet. We're going to stay around till our lease ends and let the kids finish the school year. All reasonable stuff. And then the husband stays back, finishes the school year with the kids. The lease ends and goes to Boston for 3 weeks. And then says, I'm going to go back down to Florida, but not where we lived. I'm going to go down to Miami and visit my relatives. And there's a family wedding. I know, wife, you can't come because you got a new job.
Mhm.
Goes down to Miami, goes to
Files
family
for
wedding,
divorce.
and files for divorce. So here's
Okay.
the question. When the lease ended and school ended and they went to Boston, did they intend to stay in Boston? Was that their intent, to
Oh,
move to
wow.
Boston? And if the answer is yes, and then they come back to Miami for the wedding and then decide, I want to get divorced, I'm not going back to Boston, they're no longer a resident of the state of Florida for dissolution of marriage purposes.
Sure.
They broke the 6 months.
And it seems to be an easy case to make for the court because there's a job in Boston
For the wife,
for the
not for the
wife.
husband.
Right.
Maybe the husband says, no, we were having problems before. And I told
Yeah.
him, if you take that job in Boston, I'm not coming. I'll bring the kids up to see you for a little bit, but then I'm coming back down. I'm only going to be there on vacation. Now it's a factual argument.
Yeah. That's
Who does the
fascinating.
judge believe?
Is there one way or another in that the judge normally sort of leans?
No, it's
Okay.
fact-based. So
Fascinating.
part of it would be, well, did you register a car in Boston? Did you get a new driver's license in Boston? Did you register to vote in Boston? Did you get a library card in Boston? What actions did you take? Or here you are and you're still in Florida and you're like, look, my driver's license still has my address in Florida, but you look closely at it and you're like, that was 3 addresses ago in Florida. You can't tell
Yeah.
me that you meant to stay in Florida when you're 3 addresses ago, which you're supposed to update your driver's license in 10 days, I believe. So little food for thought there.
Uh-huh.
But that's why you have to put in your petition that you've been a resident so the court has the power.
Okay.
Okay.
Fascinating. All right.
So irreconcilable differences that the court has the power to hear a case based on your residency requirement. Okay.
Got it.
Now, most people are going to go further, right? First, you're going to have to say that you're legally married, right? You can't get divorced if you're not legally married. So we were married on a certain date, irreconcilable differences. We've lived in Florida. Okay. I want a divorce. Now, you got kids, so you're going to need a parenting plan. So you're going to ask the court to enter a parenting plan. And here's the key. This is the first thing you're really asking for. If you go and say, I want a parenting plan with equal time sharing, and you go to trial a year and a half later, and you're asking for the majority of time sharing,
Mhm.
you got a problem. Because in your pleadings, you did not ask for the majority of time sharing. You asked
Hmm.
for equal. And
Yeah.
now you're showing up to court asking for more.
Okay.
The court can say, and let's say I represent the husband, Mr. Nelson, your client asked for equal time sharing. You're now asking for more. They're not on notice that you are asking for more. And they're objecting.
The wife
The
and
wife. The wife is not
representation.
on notice.
Okay.
Okay. So pleadings are called notice pleadings. You don't have to get into every little fact. You just have to say enough to the judge and to the other side. Here are the issues, and here's what I'm asking for.
Yeah.
So, judge, we need a parenting plan because we have 2 kids. I'm saying there should be shared parental responsibility. We both are going to make major decisions for the kids, healthcare, education, maybe extracurriculars are in there. But when it comes to time sharing, I want majority of time.
Mm. Mhm.
Okay. If I go to court and I ask for majority, and I'm also asking to make ultimate decision makings when it comes to education because, mom's not doing a good job on that, pull them in and out of different schools. And I go to court and the judge can say, Mr. Nelson, you asked for shared parental. You can't ask for ultimate now.
It's sort of a no takebacks, no
It's a
takebacks
very
rule.
good part. And of course,
But
in the law, there is always a way to do a take back.
well, and that's what I was gonna ask. Like, at what point do you get a chance to change your position? Is that a new pleading, or does that fall into, a petition?
2 points to that. It's an
Okay.
amended petition.
Okay.
You get a take back. I'm going to do it again, Judge. Under the law in Florida, check your local jurisdiction. It's pretty much widely accepted. It's very liberal for the court to allow you to amend your pleadings.
Okay.
Very liberal. Okay. In fact, at the pretrial conference, which is usually 30, 60 days before trial, one of the things the judge is asking is anyone asking to amend their pleadings? Last chance,
Yeah.
right? Last call. Like, here we
Yeah.
go. Okay. So you can amend your pleadings and say, I want ultimate decision making when it comes to medical and education. Okay. Here's the trick. You can also say, but in the alternative, I'm asking for shared. So you don't have to take a firm position in your pleading. You can say, Judge, I want an ice cream cone with 2 scoops and sprinkles. But if you're not going to give me that, I'll just take 1 scoop in a cup. You can ask for it in the alternative.
Okay. 1, fantastic.
Okay.
2, at what point is it too late? Judge says last call, but circumstances change over the course of a long divorce, and you might have changed your mind, or something happened with the kid and you want to amend your petition. Is there ever a point that it's too late? The trial just has to be done and then you file again for something different?
I would tell you that the absolute last time to try to amend your pleadings, and I would not suggest this, this is not a good legal strategy,
Okay. Okay.
is at the end of trial.
Oh, that seems too late to me, Seth.
Yes, it does. And here's what happens. You did not amend your pleading. You asked for shared parental responsibility and 50-50 time sharing.
Yeah.
And you put on a case in trial and you're going, I want ultimate decision making on medical. And you bring in all these doctors that say, Dad never gave the kid the medicine, never filled the prescription. Mom had to call and get the prescription filled and go to dad's to give the medication because he refused to. And you're asking for ultimate decision making in school because during the pendency of the case that lasted for 3 years, right? Dad's changed their schools 6 times, right? It's
Mhm.
not in your pleadings. You didn't do it way back when, 3 years ago. You never amended, and they put on a case defending. Dad didn't change the schools. The school burned down and he had to change schools, right?
Yeah.
Right?
Yeah, right, right.
Right? The school closed or a new school opened in our district, so they moved us, right?
Yeah.
And you're right. I didn't fill the prescription because she called and said, "Would you want me to pick up the prescription because our kid's sick and it's better for him not to go when you're home alone? I'll bring it up." You have all these defenses,
Yeah.
but you put on a vigorous defense. And then at the end of trial, your lawyer wakes up and goes, "Wait a minute, they never pled." And in their closing arguments, you say, "Judge, you can't grant them what they want. They never pled for it 3 years ago." The other lawyer says, "Judge, they just tried this issue by consent. They just put on all these witnesses. So I am asking to amend the pleadings for what's been presented in court."
Okay, so now we're essentially retroactively changing the continuity of our course
That
of our trial.
of the case, right?
Yeah.
Exactly. Not a good place to be in. You never want to amend your pleadings based on the testimony in court
Yeah,
because you
that sounds
failed
like
to
a
do it
thing that
earlier.
judges might really enjoy, striking down.
Well, if you've tried the whole case, they're probably gonna
Yeah,
be like, "Yeah, granted, we just did
yeah,
this whole trial on this. You
yeah,
consented," right?
right.
So, but you don't wanna be in that position because at the beginning
Yeah,
of trial, when they call their first witness about doctors, you're like, "Objection, not pled," right?
okay.
Okay. So,
Lots
that
of
is a
different cases,
long
but
ways to go, right?
yeah, yeah,
Okay. So, this is why pleadings are so important.
yeah,
Okay. So then the other thing, and you really got to think of pleadings, and it's going to be the same thing when we talk about motions. Okay. It is the kid going into that ice cream store with a parent. Never, when you bring a kid into an ice cream store, do you say, "Take as many scoops as you want with all the toppings and have at it."
mhm,
What it is if you ask appropriately, you may or may not receive. "Dad, can I please have a double scoop and a cone?"
mhm.
"Nope." "Come on, Dad, I got all A's. I brushed my teeth. We just got back from the dentist. No cavities." Like, they're making their case to you, right?
Yeah,
They're
yeah,
trying to persuade you, the judge. Like, "Nope, but I'll let you ask for something else. Can I have 1 scoop, sprinkles, in a cup?" "Yes, you may," right?
okay.
Because they made their argument. That argument passes for 1 scoop, sprinkles in a cup. It doesn't count for 2 scoops, all the toppings in a cone.
Because we're not trying to create a bunch of diabetic lawyers in court.
That's true,
That's really the
or at
truth.
least children,
Or children.
Okay, so you've gotta get your pleadings right, and you really need to understand what you're asking for, and it's hard because you're stressed out and it's the beginning of the case. So let me give you an example
Yes.
that I see a lot, that in Florida, you're allowed to ask for alimony, and there's different forms, and one of those forms is rehabilitative alimony, which means you want to go back to school. You want to get a certification. You want to say, "Look, I don't want to get alimony for the rest of my life. And if I need alimony for so many years, I would like it to be less because I want to get a better paying job because I know one day the alimony is going to stop and I want to be self supportive." But
Mhm.
to do that, I had 2 years of an AA degree. I've done the research. I can get my bachelor's. When I get my bachelor's, I think I can get this job making, 60, 70, 80 grand a year. Right now, I'm stuck at 40 and I'm working, but
Yeah.
my employer says they can't promote me because I don't have this my BA. And here's my path, right? And I want my soon to be former spouse to pay for that education. And here are the classes. Here's how much it's going to cost. Here's the time frame. You have to lay it all out. Okay.
Sure.
So a question the lawyer should be asking their client is, do you want a rehabilitative plan? And if the answer is like, no, I'm not going back to school, it shouldn't be in your pleadings. And if you're a client and you see the word rehabilitative alimony, you should ask your lawyer, what is that?
Yeah.
Because the lawyer's putting it in because they don't want to forget and not amend later and get to trial and not be able to get it for you. So they're going to throw in the kitchen sink. You got to ask them, what does this mean? And frequently, I will take someone's deposition who is asking for alimony, and I literally go back to the pleadings. What are they asking for? And I say, do you want to go back to school? No. Do you want to go get a certificate of any way? No. Do you want any further education? No. Are you asking your spouse to pay for any further education? No. No
Then you
rehabilitative plan.
take those out of the pleading. You just triggered something for me though, because this feels like something that attorneys are putting in as boilerplate for whatever reason. Are there other items, like checklist items around um, child support, around parenting plan, around things that attorneys just put in that we need to make sure people are aware of? Red flags that you want to make sure you talk about if they haven't talked about it, but you see it in a pleading.
The podcast is only 40 minutes, Pete.
I'm sorry, Seth. Yeah, I'll be right back. I've got to go to law school so I can keep up.
That's right. That's right. See you in 3 years.
Yeah, right.
Okay. There's a lot of stuff that lawyers put in that is quote unquote boilerplate. It's their job to explain to you why they're putting it in. And it's your job to ask,
Huge.
what
Okay.
is this?
Yeah.
You have agency. You can tell your lawyer, no, I don't want that. Okay. They're going to say, well, I suggest we put it in. If not, here's my CYA letter, which now makes you nervous.
Mm-hmm.
Oh my God, now they're going to sign that. I didn't take their advice. I'm paying them for their advice. I better take their advice, right? And I get this all the time because what happens is the first thing when someone gets served with a pleading, and this happens in motions too, which we'll talk about, like we said, in the coming weeks, but is he's asking me to pay for all his attorney's fees. They're so mad about this.
Okay.
And I say, slow down. I explain to them that they're the kid walking into the ice cream shop. They've just asked for everything. They're putting in there that they really shouldn't put in because they know that you don't have the money to do it, right? But the reason they're doing it is they don't want to forget later on. Okay. And all we're going to do is deny it. It will be an issue at trial, but do not worry about this today. But he said for me to pay all his fees. And he told me that his lawyer said I was going to have to pay his fees. I said,
Mm-hmm.
you're paying me for my advice and counsel. Do you want to listen to your soon-to-be ex-spouse? Do you want to listen to his lawyer? Or do you want to take my advice that you're paying for and I'm on your side? So you just got to like calm it down because it's very like putting gas on the fire.
Yeah.
Right.
Yeah. And I think if anything, like rather than go through all of the different things that you need to be careful of and you have to memorize so that when you see your initial pleading that you know what to make sure that you don't walk away from that explanatory meeting without understanding what everything is in there.
That's right. And not just understanding what it is. I tell my clients, I'm putting this in here because I don't want to forget to amend later.
Mm-hmm.
Being a little lazy, I'll just acknowledge that fact. Okay. And it's boilerplate. We're probably not going to get it.
Mm-hmm.
So when they say, why did you put that in there? You can tell them, my lawyer said he just does it to be safe. Probably not going to happen. Don't worry about it. Now, they're not going to believe you, right? Now, lawyers, we see this stuff all the time.
Right.
Okay. Like I can look at a petition in a point one and do an answer in another point one, like bang it out, right?
Yeah, right.
Drafting the petition takes longer because I got to make sure I get all the facts right, the birthdays, the names, right?
Yeah.
There's a lot to put in there. Talk to my client about it. But doing an answer once I've talked to my client, it's like boom, 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 boom. We're done. We can get that
Okay.
filed quickly. But the point, to your point, Pete, is there's a lot of lists, and each state is a little different in what you ask for and how you ask for it, right? But
Yeah.
the key is understand what you're asking for, Make sure it's something you want. Understand that this sets the framework for if you don't settle the case and you go in front of a judge, that this is laying the groundwork. These are the rules of the game. And then you go from there.
Okay.
Okay. There's another phrase that I want people to know that lawyers don't say often. People ask me all the time, when can we get to trial? How long will it take? You can't get to trial until, quote, the pleadings are closed. When are they closed?
What does that mean? Yeah.
Right. What does that mean?
Yeah.
It means when there's a petition and an answer is filed. And if a counter petition is filed, the other answer has to be filed. Pleadings are closed.
Because you only get one back and forth.
That's right. Now, you can ask to amend, but right when that happens, now you can try to set a trial date. Now, what the judge is going to say is, I understand the pleadings are closed, but are you ready for trial? Because pleadings get closed in the first 30 days.
Sure.
Maybe the
And it
first
can
60
take
days.
much longer to prepare for trial.
That's right. Well, you have to get all the discovery and the financial documents that we've talked about. We're going to talk about more. But so you got to take just depositions. You got to get notice of non-party production to get bank statements from the bank because the party's not giving it to you directly. There's all this stuff you need to do. Okay. So with that being said, you might want to set a mediation out. And some people say, well, I'm not setting it till I have the discovery. We'll get the discovery flowing. If they don't set a mediation, even though pleadings are closed and you're trying to get to trial, you can file a motion, and we'll talk about that next week. But pleadings are really important. Understand what they are, understand what you're asking for, understand what the other side is asking for, and whether you agree with it or not. So I just want to talk about answers and what that means.
Okay.
Any questions on the initial pleading, what you're asking for, before I go to answer?
I feel pretty good knowing the rotation here. It's good.
Your answer, there's only 3 things you're going to say. Admit, deny, without knowledge, therefore denied. That's it. That's it. Okay. Now, been a resident of the state of Florida for the last 6 months prior to filing a petition. Admit. Let's move on. Irreconcilable differences. Admit. Let's move on. Now remember, you're the one defending against this. You're the wife in this case. The wife is not relying on the husband for any sort of form of financial support. If you need alimony, you better deny that.
Yeah.
That's right. You got it, Pete. Deny. Okay. I want the wife to pay all my attorney's fees.
Deny.
If the wife has any frivolous litigation, I want her to pay my attorney's fees.
Deny.
If the wife wasted any money in the preceding these are in my petitions, in the last 2 years, I'm asking for unequal distribution of the marital assets.
Deny.
Yeah. Right.
I'm doing okay, right?
You're doing great. You're doing great.
Can I ask a question that probably will take us down a bit of a rabbit hole?
Sure.
Irreconcilable differences. Deny.
Great question. If you deny that, you better not file a counter petition, because you have to say irreconcilable differences in your counter petition. And now you've denied it on theirs, but acknowledged it on yours.
Admitted it on yours.
You deny. You go to court and you say, Judge, I'm going to file a motion. So remind me about this next week, Pete.
Sure.
And the motion is for counseling, because I don't think it's irreconcilable. And now you're going to ask the judge to force the other side to counseling.
Okay.
The judge is probably going to deny that motion. We'll talk about that more. But then when you get to trial, you can put on a case, Judge, it's not irreconcilable. Just last week, we had sex. Just last week, Judge, we went out to dinner together. We took a cruise together. It's not irreconcilable. You can put on that case. And the judge has the power to deny the divorce, saying it's not irreconcilable.
Yeah. You're obviously giving it a shot. You just had sex with them.
Well, that may or may not be obvious. There's other reasons why
Yeah.
people have sex with each other, and it's not
Well,
to save their marriage.
that's true, but, I'm just suggesting lots of
Right.
reasons. We'll litigate those reasons later. That's a
Right.
different show.
Exactly. I'm glad you didn't say we'll have sex and then litigate those reasons later, Pete. I'm a happily married man here. Okay.
Me too, me too.
Okay.
All
Good.
right.
Not to each other. Let's be clear.
No.
Okay.
Gee.
Now I'm going to do some other answers to see how you do.
Okay.
Okay. Um, I want a parenting plan. Or I want child support to be determined based upon Florida law.
That seems like an admit to me.
Right.
Am I being
You
tricked?
could say I might want to deviate because if we had a special needs kid, you might want to
Okay.
deviate because the kid needs more. But pretty
Sure.
good answer. Okay.
All right.
Uh, we have 2 children of the marriage. You're thinking a long time about that, Pete.
I felt like there was something more, like another shoe to drop. I'm gonna say admit we have 2
Okay.
children of the marriage.
All right, that's a problem. You have 4 kids. I don't know why you don't know about the other 2.
What are
Okay.
you doing? I don't even understand the legal trickery in this line of questioning.
Well, hey, look, you paused a long time, so you set that joke up. Okay. So that's the type, but look how easy it was
Yeah.
for you.
So I
right?
imagine the answers can come back pretty quickly after the petition is filed.
Yeah, and they're supposed to be back within 20 days. And if you miss it, it's pretty easy to get an extension, even if you
Okay.
get what's called a default. But I would not worry about that. So, but then it just takes a little more time to do the counter petition because you got to talk things through. Okay.
Yeah.
So, but you just rattle those off. Deny, deny,
Mhm.
deny. And literally, I talk to my clients and give them the same kind of conversation that we've had today because they've already read it. They're already fired up. And I said, look, before we go through this, let me explain it. Let me explain what you're about to reread. And I tell them, you're going to read it one more time with me. We're going to go through it very thoroughly. And then you're done reading it. I'm the one that has to worry about this document anymore, not you. Okay. So that's what we do. And just like you did, by the time they get to the third deny, they're like, deny. And they're like,
Yeah.
hell no. Can I say that? And I'm like,
Right.
no, you can only say deny. Right.
I'm
And
gonna
you-
say it. You write deny. That's fine. We have a
That's
little
right.
translation
Right.
going on.
Right. Not a chance in hell. I'll just
Yeah.
say deny.
Deny.
Right. So that's how that goes.
Okay.
Here's the other thing to be aware of. If you don't know the answer, okay,
Mhm.
without knowledge, therefore denied. For example, if you're the wife, husband files says, the husband will file a financial affidavit in this case.
Without knowledge, deny, right? I don't know what the husband's
You don't know what
gonna
they're going to do. Without knowledge, therefore denied.
Yeah.
Easy. Okay. Also, there might be a sentence or a paragraph of allegations all in one. You can break it up and say, I admit the first 4 words of this paragraph, remainder denied. Okay. It doesn't have to be
Yeah.
all or nothing. So you can split it up that way. Okay.
Okay.
Understand them. Understand your answers. Understand what you're asking for. Ask questions. It's hard. It's at the beginning of the case. You're frazzled. We're with you.
Awesome. Next week, we are turning our attention to motions. And at this point, there are so many document names floating around. I don't even know what they are. I'm very excited to learn. In the meantime, thank you all for listening. Thank you for participating in our journey through your divorce case. And send us questions. If you've got those questions, head over to howtosplitatoaster.com and click the submit a question button. It'll come right to us. We are preparing a couple. I think we've got room for 2 extended Q&A episodes coming up. They're stacking up, Seth. I think we're going to have to just take them all on.
I love those episodes.
Yeah, me too. They're some of my favorites. So they're coming. So keep those questions coming in now. Now is a great time to get them in, and we will get them answered in a new episode coming very shortly. In the meantime, thank you all for downloading, listening to this show. And thank you. We appreciate your time and attention. And thank you, Seth Nelson, America's favorite divorce attorney. I'm Pete Wright. We'll see you next time right here on How to Split a Toaster, a divorce podcast about saving your relationships. I don't think I used all the words that I needed to use there. Hang on. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, and we'll see you next week right here on How to Split a Toaster, a divorce podcast about saving your relationships. Okay. And we had a couple of people in the live stream. For those who are watching this later, thank you. You can always enter your questions in the chat or in the comments, depending on where you're watching this, and we will answer those questions live. And thank you all for hanging out. I'm going to end the stream.